Welcome to Planning for Protection.
Hey everyone, welcome into an all-new episode of Planning for Protection with attorney Jeffrey Ryder. I am your host, Mike Leon. Jeff here is an elder law and estate planning attorney serving families and aging adults all across Carroll County and the surrounding Indiana communities. Today's episode, we're going to be talking about what every Indiana family should know about probate, what to expect, and why people avoid it. Jeffrey, it's good to see you as always. Let me ask you, kind of like I love doing this with folks, right? If you're in an elevator and you've got to explain something to somebody before that hits your stop. If you had to define the word probate in one sentence, what would you say to folks out there about the word, and why does the word often cause so much anxiety sometimes for families?
Well, probate is basically the process by which a local court assists in administering and settling the person's estate. And so you have to file a petition with the court. You have to go very usually not much, but a brief hearing in which the court appoints a personal representative. There's certain duties the personal representative has. And there is sometimes an inventory required to be filed with the court, depending on the county, and whether you have supervised or unsupervised administration. So it's a process, and there's a few advantages to the process, but it does slow things down to some degree, and it is a bit more expensive because you have to have more court involvement and more time spent in the judicial process.
Well, Jeff, when people hear the word process, they probably think a long time, right? Because if you know the sports analogy, the Sixers used to say, trust the process, and that took forever. So let me ask you then, on the process part of this, like how long does probate actually take? What's you mentioned bottlenecks a little bit, but what's the biggest bottleneck in the court system that kind of keeps families from getting access to their inheritance?
Well, first of all, there is a claim process in which creditors can file claims against an estate if they believe they're owed money. And so there's a 3-month period if you publish notice from the first date of first publication of that notice. And so it's generally unwise to administer or to distribute much of anything before that 3-month period at least has run and we know what claims are going to be filed. In addition, sometimes there are issues or disputes that arise, and of course that slows things down and takes more time if heirs, for whatever reason, are not getting along regarding how the estate should be administered and settled. And there's another, thank goodness, Indiana's done away with their inheritance tax. That used to be a impediment. You could not get access to the bank account until you had a consent to transfer from the county assessor. And that slowed things down a bit. Thank goodness Indiana has seen the wisdom of doing away with their inheritance tax. So we no longer have an inheritance tax to worry about in Indiana. But the process can be slowed down. And so it's generally faster if you have a non-probate process, such as a trust of some variety, either a living trust or an irrevocable asset protection trust. So those are ways that you can speed up that process.
Yeah. Jeff, you just mentioned the inheritance tax for a second. Let me ask you about taxes or fees and things like that. So you got filing fees, you got attorney fees, you got the executor commissions. How much on average for the Indiana listener out there, or for listener just in general, like how much of a haircut, for lack of a better term, does the average Indiana estate kind of go through with respect to this process in terms of fees and all that?
Yeah, it's a little bit difficult to answer that question directly because every estate is so unique and different. And so attorneys build different ways to handle estates. A common way used to be a flat percentage of the value of the assets passing by reason of the death of the decedent. And that percentage used to be anywhere from 2 to 4% for attorney fees and about half of that amount for the executors' fees. Since the demise of the inheritance tax, though, fees have come down. And so I would say probably if you do it on a percentage basis, probably 1 to 2, no more than 3%, depending on how small the estate is. But you're probably looking at around at least probably $5,000 as a floor for an attorney fee would be my guess. So it would be vary a lot based on the size of the estate and the type of the assets that are involved in the estate, and to a degree, the number of heirs and how well they get along or don't get along.
Yeah.
Another way that attorneys bill is by the hour, and that seems like a high dollar number sometimes for people, but it is I think a fairer number because of the cost of overhead of a law office and the staff that you have to efficiently process these cases. And so you're probably looking at over 300 to maybe higher, 400, 450 an hour to administer an estate if you do it by the hour, which is why sometimes people prefer yet a third option, which is a flat fee. And you're probably looking in the neighborhood of somewhere between maybe $6,000 and $7,500 as a flat fee.
Hey, Jeff, one thing I just learned recently, and maybe you can expand on this for the audience, is that Indiana probate is a public process, right? Like I could attend somebody's probate. I mean, you tell me if I'm wrong. What does that actually mean for a family? Can somebody just walk into the courthouse or even go online and see exactly what's owned, who's it being left to?
Well, it's true that to a degree it is a public process. The filing of the petition to open the estate is a public document. The attendant things, the affidavit regarding date of death, the affidavit regarding the will, all those documents are public record. However, we, and I think a lot of other attorneys, do not put a huge amount of detail in the petition for that very reason, because it is a public document and we want to preserve the family's privacy as much as possible. So what we normally say is, rather than, one of the questions is, what is the value of the estate? And we basically put undetermined at this time, or words to that effect, which is true because we don't really know what everything's value is yet. We haven't gotten appraisals. We don't have a clear date of death value on different accounts. And it also preserves the family's privacy, so they don't have to disclose whether they have, $10,000 or a couple $1 million. It's left intentionally vague in the petition.
Mm. Jeff, a second ago we were talking about debts and creditors and things like that. Let me ask you just a one-off question here. Is there a legal risk in terms of, let's say, an executor accidentally paying a debt in the wrong order, or maybe missing a court deadline? Can you kind of explain that to the audience?
Yes. Sometimes we get executors who don't want to pay a certain person or a certain creditor. And if you've got to follow the process, as we mentioned before. If they filed a claim, we have to deal with that claim one way or another. And so there's a process where you don't have to necessarily agree with the claim. You can deny the claim, and then the creditor can ask that it be set for trial. And so if they do, then basically a hearing is set in which the judge considers the merits or lack of merits of the claim and makes a decision about whether the claim should be allowed or not allowed. And then, of course, depending on that decision, the executor has to pay that claim. If they try to avoid paying creditors, the estate can't be closed, and the judge will want to know why you didn't pay the creditor and what you're going to do about it. And if they've made distributions that they shouldn't have made, they've got to go around hat in hand to the family and say, gee, I'm sorry, but I made a mistake in making this distribution. I need to get that back from you to deal with these creditors, which, of course, is never a very good conversation to have. So it's very important not to do things without following what the law requires. And that's where an attorney can guide the person to make sure they do that.
That's right. Well said. The attorney is supposed to be there to guide, right? So, Jeff, let me ask you about cryptocurrencies and digital assets, things like that. How's the probate court kind of handling these new forms of assets?
That is a very good question. And to be truthful, I have only had one estate thus far that had any significant cryptocurrency. And we are still feeling our way through that. But it is an asset, and it is, subject to the same rules as other assets. So we will see more how that plays out as we process this first estate that had significant amount of cryptocurrency. I've had a few estates where people had cryptocurrency, but for whatever reason, they couldn't locate the key or the login information to be able to access it. So that was essentially lost to my knowledge. And I guess that's why it's important to make sure you have a record of the login information for those assets that can be accessed by your executor when you pass.
Yep. Keep the password somewhere, folks. That's something I've heard a lot. So, let me ask you about at the onset. We at the onset, excuse me, we talked about probate and this process, right? But a lot of people, I'm sure, think that a will help avoid probate. Well, if I have a will, my family's not going to go through the probate process. Can you kind of clarify for the audience why a will is a little bit just, a set of instructions for the probate, right? Rather than a way to actually bypass it.
Exactly. And we try to make that very clear to people when we do estate planning for them. If you elect to go with a will, you may or may not, depending on how you have assets titled, be subject to your estate may be subject to probate. And so you're correct. The will is basically the instructions that the court will enforce as far as what you want to have done when you pass away. And it does not, having a will does not avoid probate in and of itself. In fact, it leans towards probate being required to administer that will.
Jeff, we're talking a lot about probate and how it is such a process, and a lot of people want to avoid it. But in your experience, in your time, have you seen where actually going to court has helped the family, or it's made it easier for the family to actually go through the court process?
Well, yes. The one big advantage of probate is there is a statutorily laid out process by which you can notify the world through a publication in a local paper saying person passed away on such and such a date, so and so was appointed as personal representative. If you have a claim against them, you have to file it within 3 months from the date of first publication of this notice. And so it gives a definite time frame by which people can know if there are going to be any claims or potential creditors attempting to pursue assets. And that is it basically shortens up the period of uncertainty whereby within 3 months. Although there was just a change that was enacted here in the last week, whereby the legislature did expand the time period during which the state of Indiana could file a claim for Medicaid estate recovery to 180 days. So that is the one exception to the 3-month rule. There's a lot of advantage to that certainty, especially if you have potential creditors that you don't even know about or not sure about or don't know where or who they might be.
Yeah. Jeff, as we wrap up today's episode for that listener who kind of wants to spare their family this process entirely, what's a piece of advice, an effective tool you would recommend that they start using right now?
Well, there's a lot of ways to avoid probate. And probably the biggest and most used one may be trusts, either a revocable trust that you create during your lifetime or an irrevocable asset protection trust you might create. And both of those mechanisms avoid probate for assets titled in those vehicles. Another way to avoid probate is through beneficiary designations. If all you have is, maybe less than $100,000 in your bank account, you could put a TOD or POD designation, transfer on death or pay on death designation on the account, and then the assets would pass to your designated beneficiaries. Another big asset that passes through a beneficiary designation is an IRA or 401k retirement plan. Another one is life insurance. You have a designated beneficiary on your life insurance policy if you have one. Sometimes people don't have one, and then it falls into their estate, but oftentimes there's a particular person or persons designated as the beneficiary. Another way is through joint ownership. You could have an account that has your spouse and or your child or children as a joint owner on the account. But sometimes that joint owner is a potential problem in that they name one child, often the child that is, most local and able to, help do banking for them. But they really didn't intend for all the money in that account to go to that one child. They would rather it have been split up between their three kids, for instance, which puts a big burden on the one child to figure out, well, did mom really want me to get all this, or did she really want me to split it up? And if so, I'm going to have to make a gift to my siblings, which may impact my requirement of filing a gift tax return, depending on how much money is involved. So there's you have to be pretty mindful and careful when you start naming joint owners of accounts because of that potential for unintended consequences when you pass away.
Yeah. Jeff, thank you so much for the time, the insights, explaining all this to the audience. I appreciate it as always.
You are so welcome. Thank you, Michael, and I really appreciate your time, and you have a great day.
You too. And thank you for everyone out there listening to this episode of Planning for Protection. If you'd like to learn more or you want to consult with Jeff and his team, do me a favor, visit jriderlaw.com right now. And before you go, do me another favor. Hit like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thank you very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.